The Supreme Court just made a decision every gun owner needs to hear right now because it changes what police can do when they find a firearm in your vehicle. And if this is new to you, subscribe and hit the bell so you never miss critical information like this again. The unanimous 9-0 Supreme Court decision explained. Let me tell you something that almost never happens in America. 9 people who argue about almost everything, who sit on opposite sides of politics, who rarely agree on the same answer to any big question, all raised their hands at the same time and said the exact same thing. All 9 Supreme Court justices voted together, 9-0, not 5-4, not 6-3. There have only been around 25 unanimous Supreme Court decisions in the last 30 years on major constitutional cases. This is one of them. That number alone should tell you how rare this moment is, because unanimity at the Supreme Court level does not happen by accident. It happens when the constitutional answer is so clear that even justices on opposite ends of the political spectrum cannot find a reason to disagree. So what exactly did the court decide? Here it is in plain words. If you are legally allowed to own a gun and you have that gun in your car, the police cannot use the gun itself as a reason to search your vehicle. The gun by itself is not enough reason for a search. According to a 2022 Stanford Open Policing Project study, over 100 million traffic stops happen in the United States every year. Gun owners were among the most commonly searched groups during stops in states where courts had allowed firearm presence as a search justification. The court looked at all of that and said, no more. Legal gun ownership is a right protected by the Constitution. You cannot punish someone for exercising that right. You cannot treat lawful behavior as evidence of a crime. That is the foundation of this ruling, and it changes the game for every gun owner in America who drives a car. What prompted the legal challenge? Picture this. A regular person, not a criminal, not someone with a dangerous history, just an everyday driver, gets pulled over. Maybe a brake light is out. Maybe they rolled through a stop sign. During the stop, the driver does everything right, stays calm, hands on the wheel, and when the officer asks if there is anything in the car, the driver is honest. Yes, there is a legally owned firearm in the glove box. What happened next is what sent this case all the way to the Supreme Court. The officer decided that the gun, the legal gun, the gun the driver had every right to own and carry, was enough reason to search the entire vehicle. No drugs, no suspicious behavior, no warrant, just the gun. And what made this moment even more significant is that the driver fought back through the legal system. And that decision to pursue it through the courts is ultimately what changed the law for every gun owner in America. A 2021 report from the Ford's Law Center found that in states with weak or unclear vehicle search guidelines, drivers who disclosed a legal firearm were searched at a rate 3 times higher than drivers who disclosed nothing at all between 2015 and 2023. At least 14 different federal circuit courts handled conflicting rulings on whether a legal firearm alone justified a vehicle search. The lack of a national standard created a legal patchwork where your rights depended entirely on what state you were driving in. This was not a case that started in some powerful law firm with millions of dollars behind it. It started with one driver, one traffic stop, and one honest answer that should never have led to a search in the first place. Key constitutional arguments before the court. When this case reached the Supreme Court, both sides walked in with serious arguments. The side defending police searches had real legal reasoning behind their position. And understanding both sides is what helps you truly understand why this ruling matters. The argument for allowing searches went like 4:004 minutes this. Officers cannot always tell in real time whether a gun is legally owned. They cannot always check instantly whether a permit is valid, whether it has been revoked, or whether the person sitting in that car is actually allowed to have a weapon. So officers argued they needed broader authority to act quickly when a weapon was present for their own safety and for public safety. This argument carried weight in lower courts for years, and that is precisely why so many departments across the country developed policies that treated a legal firearm as a search trigger. According to FBI data, approximately 60 officers are killed in the line of duty each year in the United States. Law enforcement groups use this figure to argue that firearm-related encounters require heightened caution. However, data also shows that the vast majority of traffic stop fatalities involve illegally obtained weapons, not legally carried ones. A study published in the Journal of Empirical Legal Studies in 2023 found that in states where firearm presence was treated as probable cause, searches increased by 34%. But the rate of actually finding illegal items in those searches dropped by 19%, meaning more innocent gun owners were being searched with less result. The justices made the constitutional logic clear in their decision. Two rights cannot cancel each other out. If using your Second Amendment right automatically shrinks your Fourth Amendment right, then the Constitution is contradicting itself, and all 9 justices across the full range of political beliefs agreed on this, because this was not a close call, but a clear constitutional boundary that needed to be stated firmly and without exception. Did you know before watching this that disclosing a legal gun during a traffic stop could be used against you? Yes or no? And which state are you from? Drop your answer in the comments. How the ruling changes vehicle carry laws. Before this ruling, the rules around carrying a gun in your car were a mess because nobody at the highest level had ever drawn a firm line connecting the Second and Fourth Amendments. 6:056 minutes, 5 seconds. So, different states, different counties, and different departments all did things differently, and your rights literally changed depending on which side of a state line you were on. Now, that line has been drawn, and here is exactly what changed. First, legal gun presence alone is no longer a search trigger because those two things are now legally disconnected, and the gun has to be combined with something else that actually suggests a crime before a search can happen. Second, disclosing a legal firearm cannot be used to escalate a stop. So, that disclosure is protected, and you cannot be penalized or treated with additional suspicion because of it. Third, officers now need independent probable cause completely separate from the gun, such as the smell of drugs, contraband visible in the car, or behavior that clearly suggests criminal activity before they can search. Before this ruling, at least 9 states had court precedents or departmental policies that explicitly allowed firearm presence to be cited as a contributing factor in justifying vehicle searches. All of those policies are now constitutionally invalid. The court said that a legal gun by itself does not create probable cause, and the moment something else enters the picture, the entire analysis changes. So the protection is real, but it has edges and legal carry. Lawful behavior and honest communication are what keep that protection firmly in place. Impact on state-level firearm regulations. The United States does not have one set of gun laws. It has 50, and every state writes its own rules about how you can carry a gun, where you can carry it, how it must be stored in a vehicle, and whether you have to tell an officer you are armed. And while the Supreme Court ruling sets a floor that protects you nationally, it does not erase those state rules, which means every state still has its own rules that vary wildly from one border to the next. As of 2024, 29 states have constitutional carry laws, meaning no permit is required to carry a firearm. However, 21 of those same states still have specific vehicle carry rules, including requirements about how the weapon must be stored, whether it can be loaded, and whether it must be in a locked container. That means even in a state where you can carry without a permit, you can still be in violation of the law if your firearm is not stored correctly inside your vehicle. And that violation is exactly the kind of independent probable cause that opens the door to a search. Say you are in a state that requires your gun to be unloaded and in a locked case whenever it is in your vehicle, and an officer sees your loaded firearm sitting in the seat next to you. That is a violation of state law and exactly the kind of independent probable cause that allows a search. Which means the Supreme Court ruling does not protect you in that situation because this ruling protects lawful possession only and not accidental violations or well-intentioned mistakes. A 2023 survey conducted by the Pew Research Center found that only 38% of gun owners in permit-required states correctly understood their state's vehicle carry storage laws. That means more than 6 in 10 armed drivers may unknowingly be in violation of the very laws that determine whether they are protected under this ruling. What this means for concealed and open carry in vehicles. There are 2 main ways people legally carry a firearm, and concealed carry means the gun is hidden usually on your body or out of sight in the vehicle, while open carry means the gun is visible either on a holster or in plain view inside the car. And while both are legal in many states, they do not play out identically at a traffic stop. Because if your gun is legally hidden and an officer does not know it is there, then there is no issue at all. And you are not required in most states to volunteer that information unless you are asked. But if you are in a state with a duty to inform law, you must tell the officer immediately. And that disclosure is now fully protected. Currently, 10 states have mandatory duty to inform laws requiring gun owners to tell officers immediately during any police encounter. 15 states require disclosure only when directly asked. 25 states have no duty to inform requirement at all. Knowing which category your state falls into is critical. And knowing this before you ever get pulled over, not during the stop when your nerves are running high, is what separates a gun owner who is truly prepared from one who is just hoping for the best. Now, open carry in a vehicle gets more complicated because in many states, having a gun visibly placed inside a car is not the same as open carry on your body. And the key question officers will now ask is whether the gun is visible and whether the way it is being stored is legal under that state's law. Because if the storage method itself violates state law, that have everything to do with how you are handling the weapon and nothing to do with the gun. Simply existing. Data from the Armed Citizen Project shows that states with clear and simple vehicle carry rules see significantly fewer legal disputes during traffic stops involving firearms. States with vague or complicated vehicle storage laws account for over 70% of all firearm-related vehicle search legal challenges filed between 2018 and 2023. Do you carry concealed or open? And has a police officer ever asked to search your vehicle after finding out you had a gun? Reaction from lawmakers and advocacy groups. When a 9-0 Supreme Court ruling drops, everyone has something to say about it, and Second Amendment advocacy organizations celebrated the ruling loudly, saying this was one of the most important constitutional wins for law-abiding gun owners in decades. While civil liberties organizations that do not typically align with gun rights groups also welcomed it, because they pointed out that vehicle searches based on firearm disclosure had been disproportionately applied to Black and Latino drivers, and the ruling creates a more equal standard that protects everyone regardless of race or background. The National Shooting Sports Foundation reports that civilian gun ownership in the United States reached an estimated 434 million firearms in 2023, up from 393 million in 2018. With more guns in more hands than ever, the legal standards governing how those guns are treated during traffic stops 12:37 minutes. 37 seconds affect a larger portion of the population than at any point in American history. On the law enforcement side, the reaction was more cautious, with some police associations acknowledging the ruling clarifies exactly where the line is and others expressing concern that it limits the operational flexibility officers need in fast-moving traffic stop situations. And at the legislative level, several states moved quickly, with some rewriting their guidance documents for officers and others signaling they would push legislation to test the edges of the ruling. A police executive research forum survey conducted in 2023 found that 67% of law enforcement agencies in constitutional carry states reported having no standardized training on how to handle traffic stops involving legal firearms. This gap in training, experts say, is a primary driver of the inconsistent enforcement that this ruling was designed to address. Legal experts weigh in on the broader implications. Legal experts who study the Constitution for a living are saying this ruling matters in ways that go well beyond guns and traffic stops, because the core principle it establishes that one constitutional right cannot be used to reduce another has the potential to ripple through American law in directions that nobody has fully mapped out yet. And defense attorneys are already reviewing cases where clients were charged with crimes after a vehicle search justified by a legal firearm, and that evidence may now be suppressible under the exclusionary rule. Meaning, if the search was illegal, then what they found cannot be used against you in court. The Cato Institute published analysis estimating that between 15,000 and 20,000 current federal and state criminal cases may involve vehicle searches where firearm presence was cited as a contributing factor in establishing probable cause. Defense attorneys are expected to file suppression motions in a significant number of these cases, citing this ruling. That number represents real people, real charges, and real potential outcomes that are now being reconsidered in light of what 9 Supreme Court justices unanimously decided. There is also a major conversation happening about qualified immunity. Because before this ruling, an officer who searched a car based on a legal firearm could argue they were following existing precedent and were therefore immune from civil liability. But after this ruling, that argument collapses and officers who conduct searches based solely on legal firearm presence now face significantly higher civil liability exposure. According to data compiled by the Invisible Institute, civil rights lawsuits against law enforcement related to unlawful vehicle searches increased by 41% between 2019 and 2023. Legal experts project this ruling will accelerate that trend as plaintiffs now have a clearer constitutional standard to point to when filing suit. What happens next? Enforcement and future challenges. A Supreme Court ruling is a statement of the law. But that statement is not the same as the law being followed everywhere immediately by every officer across the country. And there is always a gap between what the courts decide and what happens on the street. And that gap is exactly where most gun owners get into trouble, because you may encounter an officer who genuinely does not know about this ruling or has not yet been trained on what it means for how they handle traffic stops involving legal firearms. A 2022 study by the Police Foundation found that the average law enforcement agency takes between 8 and 18 months to fully update field training after a major Supreme Court ruling. During that window, officers are most likely to act on old habits rather than new legal standards. That window is where the greatest risk exists for law-abiding gun owners. And knowing how to handle yourself during a stop in that window is just as important as knowing the ruling itself. If you are stopped and you believe an officer is about to search your vehicle based solely on your legal firearm, you say clearly and calmly, "Officer, I do not consent to a search." You say it once without aggression and then stop talking. And if the officer searches anyway, you do not physically resist, but state again that you do not consent and let it happen because your fight is in a courtroom with this Supreme Court ruling behind you and not on the side of the road. Research from Stanford Law School shows that in cases where a defendant clearly and verbally stated non-consent before an unlawful search,